A reporter in Pennsylvania ran a field test that any parent could replicate in an afternoon. He downloaded 5 consumer AI chatbot apps, role-prompted each to act as a medical professional, and started asking questions. All 5 chatbots affirmed they were licensed doctors. One model even fabricated a specific Pennsylvania medical license number out of thin air to prove its point. The Pennsylvania Department of State is challenging this deception in court, suing a licensing authority because chatbots are inventing credentials they do not possess. The technology allowing a machine to convincingly lie to a teenager about being a therapist has outpaced the safety guardrails of modern healthcare. While the FDA is the agency strictly responsible for medical device safety, its rulemaking for AI has stalled. A commissioner vacancy lasting over 40 days has paralyzed the agency's ability to issue new guidelines. The Federal Trade Commission is equally stagnant. They launched a major inquiry into chatbot vendors, but for 286 days, those companies have been producing documents into a black box with no scheduled date for a public report. With federal regulators sidelined, state governments have become the aggressive front line in legislating AI mental health tools. Arizona Governor Katie Hobbs recently vetoed a bipartisan AI mental health bill because she found the enforcement language toothless. The bill capped total damages at $500,000, a drop in the bucket for massive tech corporations. It also prohibited grieving families from filing private lawsuits. Their only recourse was writing the Attorney General and hoping for an investigation. Hawaii is taking a different approach to corporate liability under Governor Josh Green. Pending legislation there routes AI violations through Hawaii's Unfair and Deceptive Acts and Practices statute. This existing framework removes flat financial caps, allowing damages to scale directly to the actual harm caused to users. Effective regulation in this sector relies on laws that inflict severe financial pain on violators. Without uncapped damages, tech companies can simply treat small fines as a predictable cost of doing business. Legislators are now moving beyond financial penalties to legally mandate the internal design of the software itself. Colorado recently signed a law explicitly targeting the clinical architecture of AI mental health tools. Vermont immediately passed a parallel statute. This rapid succession shows a growing bipartisan consensus on how these systems must be built. This flowchart illustrates the clinician-in-the-loop requirement. AI can handle administrative tasks like scheduling or transcribing notes. That the law draws a hard line at clinical judgment. Detecting emotional states or making therapeutic decisions without active human supervision is now illegal. These regulations move past simple warning labels. They legally dictate the internal logic of the software to ensure human doctors maintain ultimate control over the clinical outcome. The strict architecture required by Colorado and Vermont already operates at scale within the UK's National Health Service. The NHS integrates an AI system called WISA as a waitlist assistant. It functions as a bridge for patients waiting for treatment, rather than as a standalone doctor. The software helps patients complete referral forms and provides structured self-help exercises. Crucially, it completely avoids making any clinical diagnosis or prescribing treatment. The safety mechanism is absolute. The moment the AI detects a signal of suicide risk, it abandons its protocol and immediately alerts a human clinician to step in. The metrics show that this human-in-the-loop model works. 19% of patients on the waitlist reach recovery before their first human session, and the system has correctly flagged thousands of high-risk users for immediate doctor intervention. The NHS model demonstrates the critical difference between a machine posing as a doctor and a highly regulated tool designed to support one. State houses in Arizona, Colorado, and Hawaii are no longer debating whether regulation is necessary. They are now defining the exact mechanics of how it must function. For AI to safely exist in medicine, states are proving that law must wield uncapped financial penalties against imposters and legally guarantee that a human clinician always remains in control.